my friends, and welcome to Unreal Life. This is your host, Danny Jovica, and we're looking at another FLAST case today. FLAST stands for Family Law Australia Support and Training. So it's a network that's there to help both lawyers and litigants alike to understand the family law better with various case reviews and digests, and that's what we're going to do today. If you want to contact the people at FLAST, there's a little Facebook Messenger thing there. You can just click on that and chat away. Otherwise, we'll get started here and have a look at this controversial with a capital C case. Now, I've got to tell you, full and frank disclosure here, I know the applicant in this case, and when I said to her, when she told me what she was about to do, I said, wow, you have got balls of steel. And obviously she's female, so we had a bit of a giggle at that, and she says, "No, Danny, I've got ovaries of steel." And I believe her, I tell you what, because it's a very, very courageous woman that can do something like this. Have a look at this case. So, give you a bit of background. The case is already in the family law courts. She has lost parental responsibility on the issue of vaccine in previous hearings because of her anti-vax stance and because of her stance on with some of her understanding of the law. Way back then, in the early days of her case, she ended up losing parental responsibility totally as a mother. So you can imagine how serious that is. And over the vaccine issue, and here she is, she knows she couldn't go to the family court and get a timely sort of response, and perhaps could have been blocked by the registrar. Strategically, she goes directly to the Supreme Court of New South Wales, seeking an injunction, preventing her former partner from vaccinating their 7.5-year-old girl. So that's what this case is about, whether it's in the best interest of a child to be vaccinated with a COVID-19 vaccine. Let's have a look at the case. Brown versus Brown, 2022, January 14. The parties are in dispute over COVID vaccination of a child, as I just said, and the plaintiff invokes the extraordinary circumstances for exercise of the jurisdiction of this court. And she filed an urgent application in the parens patriae jurisdiction of the court. So if I just get this word here, parens patriae, this is the common law jurisdiction. So if I search Google for parens patriae, what are we going to come up with? What's Google got to say? Parens patriae meaning parent of the state. And this is from the Judicial College of Victoria, so it's a very reliable source for that definition. Parent of the state, parent of the nation. It's a doctrine that grants the court and other arms of government the inherent power and authority of the state to protect persons who are legally unable to act on their own behalf. And so what she's here arguing is that she, as a parent, cannot exercise her parental responsibility because it's granted to the ex. The ex has the intent of vaccinating the child, and she is asking the court to step in and exercise the parental responsibility on her behalf, so to speak, or on behalf of the child, most importantly here. Okay, so you can imagine the controversy that this is going to cause. So Mr. Brown, the ex, is being prevented now, or she's seeking to prevent him from vaccinating the child. And the urgency was because the child was with her up until the court orders were filed, and it was handover time. So once she was to hand over the child back to Dad, she was worried that Dad is just going to go and line up and get the child jabbed straight away. She actually spoke to the father in this case and sought his opinion on what he would do. And he was fairly firmly adamant that that's exactly what his intention was, that he was going to get the child vaccinated, which is what brought about this proceeding here and the urgency of the matter for it to be a court injunction preventing him from doing that. Okay, so the summons filed by Mrs. Brown saw in effect a final order preventing Mr. Brown from allowing the vaccination. And Mrs. Brown today informed the court that she complied with the order for service. She also attempted to telephone him, and Mr. Brown has not appeared in this afternoon at the return of the summons, notwithstanding further attempts to telephone him by Mrs. Brown and a further email from the court's tip staff to him. So she's made every attempt to contact him, email, phone. The court has asked her to call him again. The court themselves have emailed him. He hasn't responded. The case proceeds now without him. So Miss Brown is in the course of being returned. Miss Brown, the child in this case, is in the course of being returned to him. If what the court proposes to do is to have any efficacy, it will be necessary for Mr. Brown to be restrained from causing or permitting any COVID vaccine to be administered. So the court has to give an injunction here. And Mrs. Brown has given an undertaking that she's going to file an application in the COVID-19 list of the family court. So COVID-19 list of the family court, again, we're going to just, I'll Google that because we'll see what comes up there. And you've got the FCOA, the National COVID list. If we click in here, this will bring us directly to the court list. See, Federal Circuit and Family Court of Australia, the National COVID-19 list. The court has got a special section there to deal with cases involving the pandemic and vaccinations and all of those types of issues. So she's got to file within the court by Monday. And the issue before the Supreme Court is whether the parents' patriae jurisdiction of the court could be invoked and the Supreme Court could make the call themselves, to which they've decided no, they're going to leave it to the specialist court. There's a little bit of case law here. Covington and Covington consider the jurisdiction of the family court to make orders in relation to the vaccination of children. That's a 2021 case, so it's a fairly recent case, but it didn't cover COVID-19. And there was another earlier case which covered whether or not a child should be vaccinated, and that predates the pandemic as well. And we're going to have a look at both those cases in a minute. So basically, there is already a distinction. There's already a question of law that is really coming up here in this case because, okay, mum has not got parental responsibility, number one. Only dad has. That's been granted to him by the federal court, the family court. And it's not on, although that was on a vaccine issue, it's not on COVID. And it's not on the COVID vaccine. And this is the question, whether or not the COVID-19 vaccine is in the best interest of this individual child. And it's going to be interesting how this case is going to be argued. We don't know yet because the order here is for her to actually file an application with the COVID-19 list of the family court. So when that case is filed and we hear about the resolution of that case, you can bet your bottom dollar that I'm going to be covering it for you guys. But in the meantime, let's have a look at and assess her chances. So in the analysis of this case, had Mr. Brown appeared, so the court said, if he did show up, the court would have sought an undertaking from him to preserve the status quo. So she was going to get the injunction no matter what, because either he was going to agree to preserve it by an undertaking or he would have been ordered to do so anyway. And the parents' patriae jurisdiction of the court is only to be invoked in extraordinary circumstances, which the court, the Supreme Court of New South Wales is viewing this matter as not fitting, just because there is a specialist court familiar with this issue, being the family court, which has a special COVID-19 pandemic list and has a capacity to deal with this matter. So the court concluded in this case that it's not going to answer the question of whether or not Miss Brown, the 7.5-year-old child, will be vaccinated. It will leave that to the family court and grants an injunction until the family court decides. So, what a result already. There's an injunction. The father cannot vaccinate this child until the family court decides this matter. But how is the family court going to decide is going to be the key here. And, really, this is uncertain. I don't think that anyone can turn around and try and say for sure that she's going to win or for sure that she's going to lose. Because let's have a look at the jurisprudence here. Covington and Covington. We'll start with that one, and that brings us over here. And I'll just go straight to the top of the screen. Covington and Covington is a 2021 case. The applicant mother contended that her consent to orders providing for the child to be vaccinated was withdrawn, and thus the orders have no legal effect. Now, the mother argues in the absence of consent, the orders contravene the prohibition on civil conscription in the Constitution. 5123A we're talking about here. The prohibition on Constitution is a section of the Constitution that essentially prohibits the government from conscripting doctors to perform medical procedures. That's the nature of that. But the argument in this case, there was no merit in these contentions, and the application was dismissed, and rightly so. Simply because, number one, I've studied constitutional law, and I've analysed the constitutional law in respect to vaccines and no jab, no pay, no play type policies, and whether or not there was conscription involved from a government position, let alone here, where it's not even the government that's doing it. Number one, it was done by consent, or it's being done by consent, sealed by court orders, under the operation of the Family Court Act. It's a federal act of Parliament, and nothing to do with conscription, and that was never going to hold up as an argument here. So if we scroll down a little bit and have a look at some of the facts of this case and where this case went. Okay, on December 7, 2020, the court received communication from the mother's Mackenzie friend advising that the mother withdraws her consent given, in her view, under duress, coercion and pressure. And subsequently, on the 8th of December, the mother advised the court that the sole issue I am withdrawing my consent for is the vaccinations for the child. How is this going to hold up? Your mum has gone to court, there's been orders made based on consent that the child be vaccinated. And now we have the mother trying to do a backflip, saying that she withdraws that consent. And the question here is, can you do that? Can you grant consent 1 minute and then, change your mind? Is that something that's acceptable? Now, His Honour listed the matter for mention on the 11th of December and unsurprisingly held that the orders were made when pronounced in the court, and the fact that they had not been formally entered on the Commonwealth Court's portal did not serve to undermine their force. So that is in relation to this contention here by Mum. The sole issue I am withdrawing my consent is for vaccinations of the child, and the basis for the withdrawal of consent was said to be that although the orders had been pronounced in court, they had not been uploaded to the portal. And I've heard this time and time again, people turn around, a judgment is in at the court. One parent is expecting that judgment is going to be enforced immediately. The other one's holding back, saying, well, it's not on the portal yet, so it's not law yet. We don't have to do it until it's on the portal. No. When the judge makes the ruling, that day, that moment, at the fall of that hammer on that judgment, it's already got force of law, and that's what is being said here. Now, in response to the inquiry, counsel who appeared for the mother at trial indicated that she had, questioned the mother closely about that. And she was satisfied that the mother was on board. Okay. Stated broadly before His Honour pronounced the orders, by consent, counsel for the father raised the concern as to whether the mother fully and properly understood the proposed orders. Now, this is a very intelligent move by the father's lawyers here. The father's lawyer is telling the court that they're not sure is the mum really agreeing to this or not. You know, the orders are being consented to here, right? And there's consent orders in place. Supposedly the mother would have signed them already. And the father's lawyer is questioning whether the mother is truly, really agreeing to this. And the response from the mother's lawyer, in response to that inquiry, counsel who appeared for the mother at trial indicated that she had questioned the mother closely about that. And she was satisfied that the mother was on board. So now you've got a deeper grave you've dug yourself here, Mum, because number one, there's orders in place. Number two, before those orders were made, your lawyer, with you present presumably in the court, stated quite clearly that you were questioned on that. Are you sure about this? Are you sure you're consenting to vaccines? She's agreed to it and she was on board. Can she just change her mind now? Is that something that can happen? Can you go to court and go through the whole process of a trial and, you know, everything else that's involved with the lawyers, and you finally reach agreement, you finally consent, and a few weeks later can you now just say, oh, I changed my mind? So on the question of vaccinations, in this court here, the mother was restrained by injunction from contacting medical practitioners about this question of vaccines. In summary, His Honour dismissed her application because he considered that vaccination was in the best interest of the child, and the mother's appeal was most unlikely to succeed. His Honour further opined that a constitutional point which was raised by the mother, and to which he'll be referring to later in these reasons, was wholly misconceived. And His Honour found that the mother's claim that she had not consented to the orders made on the 3rd of December flew in the face of evidence she gave to the court during trial. So there you have it. You know, the mother loses this case. She's injunction against her from bringing the child to a doctor. The court orders it's in the best interest of the child to be vaccinated. The court orders that her constitutional point is wholly misconceived, and not only that, her claim that she didn't consent to the orders flew in the face of the evidence. So no legs to stand on in this case. That application was opposed by the father. So the application for her to file in the High Court of Australia this constitutional argument, and the High Court of Australia ended up ruling on this as well, and found that the application lacked merit and the application was misconceived. So you have the Family Court and the High Court ruling on that same point there. So if we have a look at the decision here, the first point that we make is that although the plain intent of the mother is to challenge the order made by His Honour for the child to be vaccinated, she only appealed against the orders made on the 11th of December, and not the order providing for the vaccination to occur, namely paragraphs 22 and 26 of the orders made on the 3rd of December. So you see what's gone on here. There's a mistake that's been made by the mother and her lawyers in that they're challenging the orders for the vaccination, but they're challenging the wrong order. They're challenging the December 11 orders when the actual order that she should have challenged is the 3rd of December. And for that reason alone, the application is misconceived. However, the court goes on and says, even if there was an appeal on foot which directly challenged the orders made by consent on the 3rd of December, providing for the child to be vaccinated, the outcome would be the same. Namely, it would have no merit and should be dismissed. So either way, it was going to fall over. And the full court explained that the court is looking at the Allen case here and using that as the basis of the decision and saying that the full court explained the approach to appeal against orders made by consent is as follows. The fact that an order is made by consent does not, of course, make the order of any different nature from an order made otherwise. So the court basically says a court order is a court order. It doesn't matter if it's a consent order or if it's a judicial order by the judge. It's the same thing. It carries the same weight. It's equally as enforceable. Therefore, save for an important qualification, an order made by consent may be the subject of an appeal in the same way as any other order. So you can appeal it just the same way as you would any other order, and you've got to overcome the same appeal hurdles, which there are some important qualifications, is what Her Honour is saying, and that referred to in Gilbert is of present significance. The correctness of an order may not be appealed on its merits by a party who consented to the order. Now think about that. If you've consented to an order, you've agreed to it, how can you now appeal that the order was wrong on its merit when it's something that you've agreed to and consented to? The only person to blame here is you. And the question is, can you now change your mind? So rather that the party's right of appeal is limited to vitiating grounds. So if you are going to argue that there's a problem with your consent, it's got to be on the grounds of fraud, a mistake, fresh evidence, or the absence of jurisdiction. And that is not what is being argued in this case. What is being argued is duress, coercion, and pressure. However, nowhere in the grounds of appeal set out in the notice of appeal does a mother make mention of that assertion. So you can't file an appeal and say, my appeal is on the grounds that I'm withdrawing consent, and I'm withdrawing consent because you didn't put it in the court portal yet, is what she argued earlier. And now at trial, come around and say, oh, it was not only that I withdrew it, it was there was duress, coercion, and pressure when I made the decision. The court is not going to allow that, and especially so in this case, because this issue was brought to the court's attention. The court was informed by the father's lawyer that the father's lawyer was not sure whether the mother understood the implications of these consent orders, and the mother's lawyer responded, saying that it was something that she discussed with the mother, and the mother was on board. So how you can argue duress, coercion, and pressure in this case, I don't see it. It is submitted on the behalf of the father that, being in receipt of final orders, he should be able to act forthwith on the basis of those orders. And it's contended that to permit the mother to have a stay of these orders would be to undermine the court's process. I mean, what would be the point of a court giving orders if a mother could just turn around and change her mind, and you know, based on that change of mind, you can alter court orders, or hold the court to ransom or something to that effect. It's not going to be permitted, and that's exactly what's happened in this case. Now, this is not to say that this is the same as the case that we've just been reviewing here. This one here, where it's been filed in the Supreme Court and referred back to the family court, can definitely be distinguished from the case that we've just been reviewing. But if we continue on here, well, that's just talking here about, again, this constitutional question, which we've already covered. the mother would have to persuade the High Court of Australia that the Family Court Act, legislation that the Family Court operates under, Commonwealth legislation, Section 65 and 67 ZC, which is the powers that the court exercised in making these orders, was somehow caught by a prohibition of 5123A in the Constitution. We've covered that above. That was never going to fly. What the mother also argued in an affidavit, that the Victorian Public Health No Jab, No Play Act was also caught by Section 51. That was never going to fly because you've got federal law. The Commonwealth Constitution is different to the Victorian Constitution, and the Commonwealth Constitution has the prohibition there that says the government cannot, by conscription, force doctors to administer a medical procedure. So, in this case, that's not what's happening at all. You know, it's the family court judge who's made a decision pursuant to the Family Court Act, saying that the child can be vaccinated, and that it's impossible to try and now say that that is conscription. That would never fly. Secondly, and obviously the order was not made under the Victorian Act, is what the judge is saying, which is, you know, apart from the fact that the Victorian Act is irrelevant, it's not falling within the constitutional conscription thing, because it's not caught by that, because it's it's an act of the state of Victoria. Now, some people are going to say, okay, well, look, you know, the Victorian Act, if it's in conflict with the Constitution, it'll bring about a Section 109 challenge that, you know, federal law overrides state law. They're going to run that kind of an argument. No. You misunderstand how that argument works. You have the Commonwealth Constitution, and in this case, the prohibition is on the federal government from enacting laws that conscribe doctors to do something, like a vaccine, in example. That's prohibited, right? But we don't have that here. We have a state act. And in order for the state act to attract a constitutional issue, it must be in conflict with federal law. There must be a corresponding federal law that there's a conflict with. And where state law is in conflict with federal law, to the extent of that conflict, it's invalid. But here there is no conflict. There is no federal law on that issue. So there's no overlap, and that question does not come up. Now, before concluding these reasons, as referred to above, we need to refer to an email sent yesterday by the mother's Mackenzie friend to the doctor at B Hospital who was to vaccinate the child. The gravamen of the email is that if the vaccinations proceeded, the doctor will be committing an assault and battery at common law. The email further advised that the mother did not consent to the vaccinations and therefore should not be taking place. Let's see what the court says. The court says, prima facie, we view that as a breach of paragraph 3 of the order made by His Honour. So, rather than the court looking at this and saying, well, you know, the mother's got a point here, you know, she withdrew consent, and without consent it's assault and battery. No. The court says, the court ordered that the child be vaccinated. The mother consented to that. It's part of the orders. So that act by the mother is in fact a breach of court orders. You see what's happened here? So the mother cannot just unilaterally change her mind. This is the problem here. And, you know, in this case, obviously that's why she's lost. Her argument was really put forward quite poorly there. Orders have been made in this court to facilitate the vaccination of the child. The vaccination of the child is, in these circumstances, entirely lawful. The mother's contention that somehow for the vaccinations to proceed would be assault and battery and in breach of patient-doctor relationship is entirely misconceived, erroneous, and must be rejected. And we agree is this court's comment to that issue as well. So you can see what's happened here. This case where it's gone wrong for the mother in this case. But this is still not like our case over here. We still have a number of distinguishing factors here that can be distinguished in these two cases. And the question still remains whether it will be in the best interest of this child to have a COVID vaccine. So let's have a look at the next case that was presented to us. Now, this case is Maines and Redden, 2011 case, which is sort of the standing precedent on vaccinations and the positions of the court for that purpose. So we'll just sort of scroll down in through this case and have a look at where we've highlighted some information. Okay, we start off at 31 here. In further support of this challenge, counsel for the appellant relied on the mother's affidavit, evidence in chief, in which she said, "I have never said that not vaccinating the child has been ingrained to me, that the Australian government is corrupt, or that vaccinations cause mad cow disease." So it looks like somewhere along the way, someone made allegations that she was an anti-vaxxer nutcase type thing, and she's denying that. The appellant clearly, as she articulated in her affidavit evidence in chief, opposed immunisation of the child. So here she's saying that she is not an anti-vaxxer, but the court does note that despite what she says here, she's opposed the immunisation of the child. So she's opposing the vaccination whilst claiming not to oppose vaccinations. I believe vaccinations on the whole are beneficial for our society. However, in the circumstances of the child's health, I have overwhelming reasons not to vaccinate, and refers to the experts that she refers to. Clearly, the mother is not a crank, is what the court commented. Clearly, she's not a crank who rejects all medical advice and information. That's the court's comment here. On the contrary, she is well read on the risks and benefits associated with vaccination and has sought medical advice and implemented prescribed treatment wherever necessary for the child. She's providing a healthy and loving environment for her daughter, and the child is healthy, happy, normal, developing as a result of this effort. So the court recognises, she's doing all the right things that she's supposed to as a mum. The mother has discussed vaccination on occasions with myself, has full knowledge of the medical benefits, and has extensively investigated the pros and cons of vaccination and decided personally not to vaccinate the child. This is the comment of the child's, of the mother's doctor, providing evidence into the court that the mother has thoroughly researched this. The court, or the father's side of things, heard from Dr. W. Now, Dr. W recommended immunisation on the basis that there was no unacceptable risk to the child. So you have competing experts here. One is the mother's doctor, the paediatrician, who knows the child and says there's a risk. And the other is this Dr. W, who's recommending immunisation on the basis that there is no unacceptable risk. So it's not saying that there's no risk, there's just no unacceptable risk. He asserted that the immunisation as recommended by the Department of Health and Ageing should be implemented. He noted that the likelihood of becoming infected with specific vaccine-preventable disease is difficult to quantify. There are many factors that influence risk: the conditions of living, the environment, the population mixing patterns, infection control practices, school infections, international travel, host immunity. There's a whole range of factors that could see that child be exposed to the disease, which is sought to be prevented by the vaccine. By being immunised for measles, mumps, rubella, diphtheria, tetanus, pertussis and varicella, the child will not need to be withdrawn from school or from visits with her father, her stepmother, and any potential further child that they might have. So the court is saying, okay, aside from the fact that, it's in the best interest of the child because the doctor says, there's no unacceptable risk, the court is also recognising that if the child is not vaccinated, it might have other social implications where the child might need to be withdrawn from school, or have other social impacts which affect the child's development. The question came up about a medical procedure, whether a vaccination is a medical procedure, and there's a lengthy discussion in this case about this very question, where the counsel for the mother or the appellant submitted that the application for immunisation of the child in the present case fell within the ambit of medical procedure application rules, what they're calling MPARs, and involving a major medical procedure for a child that is not for the purpose of treating bodily malfunction or disease. And counsel for the respondent submitted that the application for immunisation of the child in the present case was not governed by the MPARs. So, Mum says this is the rule that applies. It's a major medical procedure for a child, and it's not there for treating a bodily malfunction or disease, so the court needs to apply the rules for a medical procedure. Immunisation was not contended to be a medical procedure falling within MPARs, is what the father argues. It was submitted that both parties at trial dealt with the issue as a subset of parental responsibility and focused on the best interest consideration. So, here's your problem. At trial, Mum turns around and they're happy to do things by consent orders, making it an issue of parental responsibility. It's all just about generally the best interest of the child, and both parents agree as part of consent orders. That's all covered within that ambit. Now, you can't go on to appeal and say, well, no, it's not that. It's a major medical procedure now. You're sort of conflicting against what you originally were arguing. And counsel for the respondent submitted that since neither of the parties at the proceedings at trial had purported to make a medical procedure application under the MPARs or referred to the immunisation of the child in those terms, the federal magistrate need not, and correctly did not, turn his mind to those provisions of the rules, tied by the fact that no one had made an application, which is what I just said. You know, you can't not make an application earlier and now suddenly try and say that this is falling within this ambit of an MPAR, medical procedure. Having said that, though, the court did have a look at this in a bit more detail, and again, the court says it's elementary that a party is bound by the conduct of his case, except in the most exceptional circumstances. It will be contrary to all principles to allow a party, after a case has been decided against him, to raise new argument which, whether deliberately or inadvertently, he failed to put forward during the hearing when he had an opportunity to do so. Again, it's the same point. You can't go to appeal on something that you've not argued in the main trial. That is something you should have argued from the beginning. And this case here that we're talking about here, this Supreme Court case that's been referred to the family court, is going to face a similar problem. If they try and argue that it's a medical procedure, then why didn't they argue this earlier in the proceedings? But the question here is still up in the air, because in the earlier proceedings where the court ruled that the child could be vaccinated, that was according to the schedule. Here we have an experimental vaccine in the COVID-19 mRNA vaccine, which has never been used on humans before, let alone children. And arguably, the COVID-19 vaccine is different to the ones in the schedule. The court goes to say, in light of those cases, it's difficult to accept, in the absence of evidence of a significant risk to the health of a child of doing so, that immunisation could readily be accepted as constituting a procedure which fell within the ambit of MPARs. So the court is sort of saying that, looking at all the history of the cases that have covered that, it's not really falling, vaccines don't really fall into that category. The mother argues that they're going by the definition in the dictionary, that it's a medical procedure, and accepting that that immunisation is a medical procedure. To attract the operation of MPARs, it must be a major procedure and not excluded. And the second requirement of the definition of a medical procedure is that the procedure is not for the purpose of treating bodily malfunction or disease. So arguably it's not. A vaccine doesn't treat a bodily malfunction, nor does it treat a disease. It's there theoretically to prevent the disease, not treat it. Now, in support of this contention that immunisation is a major medical procedure, the argument here is that if the child does have a sensitivity, the outcome is irrevocable. If the child has a severe reaction, that once that happens, it's done. The damage is done, and that in itself makes it a major medical procedure. And the question in this case is whether it is a major procedure for this particular child. A test which a prudent federal magistrate would apply, because the rules are reflective of the legislative framework, which is always in the best interest of the child, is that the procedure is necessary for the welfare of a child. And this is the way that the court looks at it. Is this necessary for the child's welfare? Is it in the child's best interests? And that question, the court considers social impact as well as health impacts, as we discussed earlier. Things like, will she be able to go to school if she's not vaccinated? Will she be able to go to kids' parties or sporting events or restaurants, or who knows what the rules might be in regards to COVID-19 and vaccines. The immunisation question does not sit comfortably with the rules as drafted, is what the father is arguing. The intention of the legislation is to deal with significant medical procedures, and the father argues immunisation is not one of those things. That the provision envisaged to deal with something that occurs less frequently. This major medical procedure is sort of envisaged to these rare things where might be treatment of a cancer or some other rare disease, and now the doctors are recommending one thing and the parents are not comfortable with that, and then they go to the court. Major. So the father argues that this is not major. The particular condition of the child for which the procedure is required is a factor that needs to be taken into account. So here you have a healthy child, and procedures that are needed for a specific child, and not something that is done on a routine basis. So the father's argument, vaccines are routine. This is not major. This is a routine thing, and this MPAR condition is not met by the mother. Counsel for the respondent also suggested that there was evidence from one of the experts about testing the child for antibodies prior to immunisation. So this is like your Novak Djokovic case, isn't it? He argued that basically he's already had COVID, and as a result, he's already got the antibodies in his system, and he doesn't need the vaccine. But we saw what happened in that case. The government took the stance that, according to ATAGI guidelines, having antibodies and having caught COVID before is not a valid reason not to be vaccinated. So that one won't fly. Immunisation of the child was for the purpose of preventing disease rather than treating a disease. As such, it's difficult to accept that immunisation necessarily could not enliven the operation of MPAR. So the court recognises that, hey, there can be a circumstance where we might say that vaccines could enliven the MPAR, that it is a medical procedure. So this is what we're saying back here. This case is truly interesting because the court has left it open for an MPAR argument to be there. And if the original argument or the original matter that was before the court, which as it was in this case, was not about COVID vaccine, but about other vaccines. And COVID vaccine is new, it's novel. In fact, the government has only just now, in the last few days, approved it for use in children. That's how new it is. So it was not a consideration back then. So in this case, the applicant can argue an MPAR. Interesting. In the present circumstances, the evidence did not establish, but for immunisation, the best interest of the child would necessarily or more probably be compromised. The issue was clearly whether such benefits would have resulted from immunisation were outweighed by the likely risk of the child having a significant adverse response. It would be difficult to conclude that immunisation constituted a medical procedure within the provisions of MPAR. So, that's the finding of the magistrate. But if the findings of fact enliven the MPARs, the matters referred to in them would need to be addressed. So the argument is there. It's a valid argument, and it's going to be really interesting how this one pans out, because this case has been referred to by the Supreme Court in bringing this forward. Now, in her affidavit, Dr. C deposed that given Dr. C is the family doctor, obviously, given the family history and my examination of the child, it's highly probable that the child would suffer adverse vaccine reactions ranging from worsening eczema, recurrent infections, fevers, and the possibility of development of behavioural disorder. While it's impossible to say exactly what reactions the child would have to a vaccination, it could also induce more serious adverse reactions, such as an autoimmune condition, cardiac damage. Now, that's what we're seeing now with this, COVID vaccines, this myocarditis and pericarditis and inflammation of the heart, and, people who are facing, perhaps lifelong treatment to prevent that condition from getting worse that has been triggered by that vaccine. Severe anaphylaxis, gastrointestinal disorder, neurological disorders, respiratory conditions. That's what the child's doctor is saying, that these are the reasons why we shouldn't give it to the child. And I am particularly concerned about the administration of a DPT vaccine at this point in time, as the child has only recently suffered serologically proven natural pertussis. So the child already got it, and he's already has the natural immunity to it. So doctors arguing, what's the point of having the vaccine when the child already got the actual disease and has the antibodies to deal with it now? The doctor goes on to say, undertaking the tests that she's ordered. So she's ordered tests to see, if there's any allergic reactions or that kind of thing. And as the child is now over 6 years old, she's no longer in the age bracket where measles or varicella are dangerous diseases. So there's no urgency to vaccinate in the near or distant future. So these are all coming from her doctor. I would recommend that Gardasil be withheld until the child is 16, and counsel for the respondent sought to rely upon the evidence of Dr. M, which we covered a bit earlier up there. And Dr. M is a pediatric clinical immunologist, an immunopathologist with a specialist postgraduate qualifications in those fields, who has practiced at a consultant level at the Children's Hospital in Westmead since 1998. So the father's brought in the big guns. This is a clinical immunologist, an immunopathologist, consultant to the hospitals. And Dr. M's evidence was sought to be relied on by counsel for the respondent to buttress in the decision of the learned federal magistrate. So that's another case where he was called in as an expert witness. And now, without expressing or needing to express any concluded view in relation to the issue, Dr. M's relevant expertise, at least in a formal sense, having regard to her report and the affidavit of Dr. C, may be superior to that of Dr. C. So, there you have it. You got the expert who says, I've had a look at what your doctor has said, and your doctor's wrong. There's no risk here, and the child should be immunized, and that's exactly what happened in this case. Because the risk of the child suffering a significant reaction to immunization is extremely remote, is essentially the bottom line here. So this case went against the mother. So far, when you look at all the cases that are coming through the family courts, I'm not aware of any where the mother has won on the issue of vaccine. However, this is the first challenge on COVID-19. And let's have a look. Are COVID-19 vaccines a risk? We can go to the TGA database. This is the database of adverse event notifications. And I've selected 4 medicines. This is Comirnaty, which is the Pfizer vaccine, COVID-19 vaccine, TNS, the AstraZeneca, Spikevax. So these are the 4 vaccines that have been approved for use in Australia. And what's the outcome? By the way, the time frame that I've done this search for is from the 1st of March 2020 to the 6th of January 2022. So, in that period, we've got the number of reports, 100,637 adverse events reported. 100,000 people have been injured by this vaccine. These are adults, by the way. We've just started the children vaccines. And from those 100,000 cases, 98,834, there was a single suspected medicine. That means the vaccine was the only possible thing that was being considered as a factor in that most of those cases, 98%. And the number of cases where death was a reported outcome, the person died in the end. So you have generally they were alive before the vaccine, they get vaccinated, and now they've died. That 736 doesn't say that the vaccine caused it. There might have been underlying health problems, but there was a correlation, and certainly 736 people died straight after getting the vaccine is what is known here. When we look at the types of injuries that are resulting in death, you got respiratory injuries, thoracic and mediastinal disorders, a thing called dyspnea, which if we have a look at that and see what that is, I'm not quite sure. So we got a Mediline Plus is the thing that comes up as a straight up search, is difficult or laboured respiration. So difficulty breathing after you have the vaccine. So, and 149 people died, from that kind of an adverse event. 68 people died from that. Injury, poisoning and procedural complications, 149. Pulmonary embolism. So again, a respiratory and type disorder here. Cardiac arrest, cerebrovascular accident, brain damage. So the list goes on and on of the types of myocardial disease, cerebral hemorrhage, pneumonia. This is the list, and that's page 1 of 63 of adverse events associated with the COVID vaccine. And Mummy's saying that this doesn't make sense to give to a child who who's strong and healthy and has a good immune system. to a disease that children are known to be, fairly resilient to. No child has died from it or from COVID or anything like that. So, Mummy's saying that, hang on, the risk of damage of the child being hurt is greater if they're vaccinated than if they actually get the disease. Is Mum right? I don't know. This is the case to look out for. This case will be going to the family court. What are your views? Should the 7.5-year-old girl have the COVID-19 vaccine? Or is Mum right that it's just too big a risk, that we shouldn't allow a 7.5-year-old to be vaccinated when there are such risks there, and there seems to be little benefit here. This is not your standard vaccine. This is an mRNA vaccine that we're talking about. So if we go back to that TGI database, these vaccines, these mRNA vaccines, what does Google say about those sort of things? Messenger RNA vaccines teach our cells how to make a protein that will trigger an immune response inside our bodies. This kind of thing we've never done before. We've not used that kind of vaccine before. And like all vaccines, mRNA vaccines benefit people who get vaccinated by giving them protection against diseases like COVID-19 without risking the potential serious consequences of getting sick. And that's really the question here. If the child actually got COVID, what would the implications for that child be? And is the risk greater from 100,000 reported incidents here of very severe reactions? Is this risk greater to the child? You be the answer to this. Let me know what you think of this video. Let me know if you think the child ought to be vaccinated. What do you think of the case? What do you think of the legal arguments here that the mother has put forward? What are her chances of success? I don't know, but let's talk about it, because this is going to be a big one. Thanks for your time today, and don't forget to click the like button. Share this video with anyone who you think might benefit from learning about this case. Hit the subscribe button so you can be subscribed to this to the IMREAL.LIFE channel, and that notification bell, don't forget to hit on that, because when I do publish the next case, and it's going to cover what happens in this one in the family court, you'll be the first to be notified. Good on you, and see you soon. Cheers.